Coming up next on C-SPAN, coverage of the finals in the Moot Court Competition held in May at the University of Chicago Law School. The contest is a year-long program for second- and third-year law students named for former Judge Edward Hinton. In this program, students argued in the case of Price Waterhouse versus Hopkins, an actual case decided by the Supreme Court this year involving alleged sex discrimination against an employee of Price Waterhouse. The judges in this Moot Court competition include Supreme Court Justice Sandra O'Connor.
Oyez, oyez. All rise. The Honorable Supreme Court of the United States is now in session. Justices Breyer, Archer, and Chief Justice O'Connor presiding. The court will now hear argument in the case of Price Waterhouse versus Hopkins. You may be seated.
Is the petitioner ready?
Yes, Your Honor.
You may proceed.
Petitioner requests 3 minutes for rebuttal. The time is to be taken from Ms. Finston's presentation. May it please the court, my name is Catherine Winterburn. My co-counsel Nina Finston and I represent Price Waterhouse as petitioner in this appeal. We will be arguing 4 points. I will address the first 2 of these points. First, the theory employed by the lower courts did not distinguish between direct evidence of discrimination in the process and the ultimate decision. Second, liability under Title VII requires a showing of but-for causation. Ms. Finston will argue, third, that the burden of proof does not shift to the defendant to disprove but-for causation. The plaintiff maintains the burden. And fourth, that if the burden does shift to the defendant, the standard of proof is preponderance of the evidence and not clear and convincing evidence. This case offers the court an opportunity to weigh the competing equities between employers and employees at 4 junctures: in reviewing the appellate court's theory of liability, in deciding on the degree of causation required, in determining the burden-shifting issue, and establishing the standard of proof. We feel that the equities weigh in favor of the employer at each of these junctures, and we therefore request this court to reverse the decision of the appellate court and remand for a showing of preponderance of the evidence if the court decides that that is the appropriate standard. In challenging the legal framework employed by the lower courts, we recognize that many of our objections verged on disputes with the factual findings. In light of this court's limited scope of review, we will adopt here a more conservative approach and suggest 3 limited, discrete objections to that framework in order to gain clarification from this court. First, under the infection theory, the lower court mischaracterized a few isolated comments as direct evidence of discrimination in the ultimate decision process. The theory offers no recognizable distinction between direct and circumstantial evidence. Respondent demonstrated only evidence of generalized discrimination, but discrimination in the air is not direct evidence. It may show only a prima facie case of discrimination. Second, the theory did not distinguish between discrimination within the process and the requirement that the ultimate decision be a product of discrimination. Very little evidence served as a causal link between the individual instances of impermissible bias and the ultimate decision. The presence of sexist language does not conclusively indicate anything about the decision of the entire partnership. The theory allows all credible direct evidence of discrimination as proof of a substantial motivating factor in the ultimate decision, and thus gives tenuous evidence, as here, inordinate weight.
Counsel, I thought in the lower court they had quite a lot of evidence that said things. People made remarks, you could wear nail polish, take the lessons charm school, and that the district court said, well, there were quite a few remarks like that, and in addition to that, they did it before, in other instances. In addition to that, this was sort of an ongoing problem. Nobody ever did anything to try to educate these people that, you know, it isn't necessarily that you have to have a woman taking lessons in charm school, etc. And on the basis of that, he says, well, that's evidence that these people are discriminating, at least unless they had some other good reason, which probably they didn't have.
The district court...
What's wrong with that as evidence? I mean, isn't it up to the district court? We're not supposed to review that, are we?
No, Your Honor, but the district court said that there was no direct link between the comments and her ultimate decision. It based its finding of liability on foreseeability on the part of the entire partnership. And what we are questioning is how we can separate the partners from the partnership, and in establishing liability on that account, they allowed the respondent's expert, Dr. Fisk, to draw the causal link between the comments and the ultimate decision in this case.
Did the district court ever make an ultimate finding whether or not the sexual bias was a but-for cause of the decision?
Yes, Your Honor, the appellate court did apply but-for causation, and that is the standard that we would argue in favor of.
Did it ever make an actual finding of but-for cause, do you think?
It did not. It made a finding that there was ultimately the decision was a product of discrimination in this case.
Might have been a little fuzzy about what the
Right.
Not altogether clear, I think.
There's
Do you
a risk.
think the statute itself requires the plaintiff in this case, in a Title VII case, to bear the burden on the issue of causation?
My co-counsel will more fully address that issue, but yes, we feel that the statutory language which speaks in terms of liability being imposed when an unlawful employment practice is to discriminate against any individual because of such individual sex, does impose a burden of but-for causation. And my co-counsel will argue that the plaintiff should retain the burden of showing but-for causation. Our respondents argue that significant factor should be the level of causation required, and we disagree with that and believe that...
Well, that seems to be the standard most of the lower courts have applied, isn't it?
Well, in fact, Your Honor, 7 circuits apply but-for causation. There's a difference in who they require to show but-for causation, but on the ultimate level of causation, 7 do require but-for causation.
But they also apply a substantial factor test, do they not?
Yes, but they speak in terms of the substantial factor or motivating factor, and then some will shift the burden to the defendant to disprove. The defendant has to show but-for causation instead of the plaintiff.
Do you dispute that there was sufficient evidence here to show a substantial factor being present of the stereotypical?
We do not think that the comments in this case bore on the ultimate decision of the plaintiff, of the partnership. We think that there is obviously direct evidence that the comments were made. We do not dispute that finding. But we do not think that we think that the causal link is tenuous here. It definitely does not rise to but-for causation, and we would suggest also that it does not rise to significant factor
What
as
evidence
well.
did you present before the district court to rebut the testimony of Dr. Susan Fisk?
I do not think we presented another expert to rebut her evidence.
Was there any recognition of Dr. Fisk's ability as an expert to testify? Wasn't there indeed, I think, a stipulation in the record or an acknowledgement by Price Waterhouse that they were not going to question her ability to evaluate the written statement and to formulate her opinion?
The district court made it allow Dr. Fisk to testify as an expert, and what Dr. Fisk did is she also stated that she could not say exactly what any comment, the effect of it, that any comment had on the ultimate decision in the case. She merely testified that there was infection in the process and that stereotypical comments were being allowed to enter into the process. But we do not think that a handful of comments can necessarily indicate that the ultimate decision of the entire partnership is influenced by discrimination.
Well, necessarily is the key word. I mean, we have a district court judge finding that comments like, hey, go to charm school, you ought to dress more femininely, you ought to wear makeup, you ought to have your hair styled, you ought to wear jewelry. I mean, we have a district court judge who's decided that in context, a number of comments like that in advice and past behavior suggest that at least a kind of stereotype, i.e., act like a woman, all right, that kind of stereotype played a role, a substantial role. Are you asking us to overturn that fact finding?
Many of the comments that were made were also made by respondent supporters, and the evidence that Dr. Fisk gathered went to the infection of the process, but they did not go to whether the ultimate decision that was made not to promote her was influenced by those comments.
But as Judge Breyer points out, this court seldom sits to disagree with the factual findings of the court below.
Yes, Your Honor, we recognizing that. We are worried, though, that allowing the district court to characterize this evidence as direct evidence will have an effect, because in this case, the appellate court said that since there was direct evidence here, that they would depart from the McDonnell-Douglas framework and Burdine, but if their circumstantial evidence had been present, which we think these comments were, they would have maintained that framework. And that is what we're worried about.
Well,
We dispute their legal definition of direct evidence.
you think the comments of partners about past women candidates and the way the Price Waterhouse system was structured were irrelevant to the showing of a discriminatory motive?
They are not irrelevant, but those comments made in the past also did not bear on the ultimate decision in this case, and informing the direct evidence that this ultimate decision in this case was a product of discrimination of those remarks.
But if this isn't direct evidence, what would be? I mean, I know that you point out in your brief, you say, well, it was a supporter that said go to charm school. Well, that's true. It was a supporter. But obviously it was a supporter who knew how his partners were likely to react. Right? I mean, so if in fact you have, I mean, what do you want? Are you saying the only time that the direct evidence means when the person who actually does the hiring says, I don't want you because you're a woman? I mean, those won't be many cases.
Right, and the lower courts have recognized that there rarely is direct evidence in these cases. Direct evidence would be a comment of, I will not promote a woman, I will not hire a black for this job. That is direct evidence. These comments required inferences to be drawn by Dr. Fisk to show that they indicated discriminatory animus. For instance, the charm
Well, now,
school.
is that true? It seems to me you had all of these comments that were made, and Dr. Fisk's evidence was something quite different. Was there enough evidence without Dr. Fisk's testimony at all?
Dr. Fisk was allowed to establish the causal link in this case. The district court clearly pointed that out. Price Waterhouse turned over everything that went into this promotion decision, and it was Dr. Fisk who pointed out to them that they had stereotypical attitudes because of a handful of comments that were made, highly ambiguous and tenuous comments.
I suppose that I thought that perhaps the distinction between the direct and circumstantial evidence is this, that sometimes you do have a case where a plaintiff, who is a woman, says, this is my evidence. A, I am a woman. B, I didn't get the job. C, I was qualified on paper. And D, they gave a job to a man. Now, I suppose under those circumstances, that's an instance where you don't have direct evidence. Then you might distinguish that case, which is enough to get you a verdict if there's nothing else there, from a case where, in addition to that, you have some comments, a little past history, a few other things thrown in, such as, hey, go to charm school, etc., of that variety. And those are the cases that are direct, and the cases otherwise are what you might call pure circumstantial, namely those little elements that just get you what's called a prima facie case. Now that's what I thought the distinction was aimed at. Now do you think that's right, that is the distinction, and do you think it should be? Do you think there should be a different distinction, and if so, what should it be?
I think that that circumstantial evidence means that inferences have to be drawn where comments are involved of what the intent behind the comments is. And when you have a highly ambiguous comment like the plaintiff, the employee should need the class in charm school, that comment can be taken to mean A, that the employee is a woman and should adhere to some certain standard, or B, that the employee does not get along well with her employer, the employees beneath her, and that she needs to change her interpersonal skills and change her management style.
Could we address perhaps that which apparently made her a standout? Didn't she, the record reflect that she was perhaps one of the best business getters of any of the, how many partners were up for people considered for partnership, do you recall?
80, Your Honor.
There were 80. That she brought in some $22 million worth of business from the State Department?
Yes, Your Honor, but the interpersonal skills that the district...
Now let's just start with that if we could. She brought in $22 million worth of... Did anybody else who was up for partnership do that?
No, Your Honor. They found that she had brought in the most business on that criteria.
Was there, how many males were up?
She was the only woman up, so that was 79 males.
Were any of the males asked to walk more masculine?
There's no evidence that any males were.
Were they asked to talk more manly?
No, Your Honor.
To dress more like a man?
I would point out, Your Honor, that that comment was made by one of her supporters outside of the evaluation process. And he was speculating.
Let us address that for a moment if we can. There is a admissions committee who then gathers information, who makes recommendations to the policy board, and the policy board can either make a recommendation that a person becomes a partner, that a person is on hold, or outright rejects. Is that correct?
Yes, Your Honor.
And if a person, as she was, recommended to be placed on hold for a year, theoretically they'd come back and take a look at her. She apparently, or anyone who was placed on a hold, was apparently supposed to do something to correct whatever it was to allow them to attain partnership.
Yes, Your Honor.
And so to hear from a person who suggested to her that she should do more things of a feminine nature in order to better place herself in a position to become a partner, wouldn't it be realistic to assume, or perhaps circumstantially correct to believe, that there has been some discussion about what it is that she should do in order to place herself in a position to become a partner?
But allowing one individual comment outside of the process involving mere speculation about what might have been the problem with respondents to invalidate the entire process and require Price Waterhouse to call in sensitivity experts, that is clearly goes beyond what Title VII requires of employers and subverts the recognition that employers do have important rights under Title VII to maintain their management prerogatives and to maintain their businesses as efficiently and effectively as they can. The district court found that interpersonal skills was a valid criteria and that Price Waterhouse had a legitimate non-discriminatory reason for not advancing the respondent. She did get along with her clients. She did bring in a lot of business, but she did not deal well with her management staff. They said it took guts to get along with her and that she was abusive to them. And the district court found that Price Waterhouse had maintained its showing that this was a legitimate non-discriminatory reason and that this employee would not have been promoted. Absent these comments, they could have legitimately not have promoted her based on her lack of interpersonal skills.
Which brings us to the issue of mixed motive. Is that something that you're prepared to discuss with us?
Yes, Your Honor, as far as the ultimate level of causation.
Would you describe for us how you would want our court to rule regarding what appears to be a mixed motive? On one hand, it appears that she was asked to be more of a woman, more feminine and the like. On the other hand, you argue that there was sufficient evidence on the record that the trial court should have found that there was a legitimate reason, because of lack of interpersonal skills, etc., to become a partner or be placed on hold. How should a trial court, look at the two competing rationales for the decision not to make her a partner?
In weighing the competing equities, we believe that but-for causation is the proper standard, that it should be shown that but for the discrimination, the decision would have gone in favor of the plaintiff if the plaintiff is showing it, or in favor of the defendant if the defendant is showing it.
Who carries that burden of proof?
As my co-counsel will argue, the plaintiff should bear that burden of proof.
All the way through?
Yes, Your Honor.
Even if she sets forth a case, sets forth the facts, and brings in an expert. But incidentally, did anybody prevent Price Waterhouse from presenting an expert?
No, Your Honor, they did not.
Thank you.
With anything less than but-for causation, the employee would not only receive attorney's fees, but they would also act as a window through which this court could enter and impose broad injunctive relief, such as mandating sensitization training and the broad-scale restructuring of subjective business practices. This would subvert the recognized purpose of Title VII to guarantee equal employment opportunities while maintaining traditional management prerogatives to organize their businesses. But-for causation is the proper standard here. It fosters the appropriate inquiry into the motivation and thus the true basis for an employer's decision, thereby ensuring that only illicit conduct undertaken for illicit reasons and prohibited by the Act is precluded. The significance...
Why is but-for causation involved in this? I mean, what I'm having basic trouble with is this. You're asking us, the issue is whether or not the plaintiff has to show at a certain point that really the employer has to show that he would have the employer may have to show that he would have not given her the better job, this other good reason. Or alternatively, the plaintiff may have to show that even though he said he had another good reason, still she has to go on to show that he would have given it to her, right? Or I can hardly say that. It sounds like abacus stuff. Now, the reason that I ask that is, why are we deciding this? I mean, isn't it the case that basically a plaintiff will go into a court and he'll say, Judge, they discriminated against me, put in a whole lot of evidence. And then the defendant say, no, I didn't. And he'll put in a whole lot of evidence. And then the judge will figure out either they did, not give her the job because she was a woman, or they didn't. Now, what has the burden of proof really got to do with it in a case that's going to be tried by a judge? I mean, I guess there might be an instance where it was in equipoise, whatever that means. I guess balanced on a knife edge. I've not yet seen that case where the judge actually felt it's balanced on a knife edge. Usually they say, hey, I think they discriminated. Or they say, no, they didn't discriminate. Why are we trying to decide this highly theoretical issue here? And you're the ones who've asked us to decide it.
In a mixed motive case, the interests of the employer and the employee are in equipoise. The employee has demonstrated there was discrimination in the process as is here, and the employer has shown that they have a legitimate non-discriminatory reason.
There are two independently sufficient causes, you say. One legitimate and one illegitimate. Now, under those circumstances, why is it that the employer should not have to come forward now and establish the real reason?
Because we're trying to determine what was the ultimate reason that the decision was
Well,
made.
who knows better than the employer? I mean, if we had an equal protection case, such as in Arlington Heights, the burden of proof on the issue of causation does shift to the defendant after the plaintiff comes forward, as was done here. I mean, why shouldn't we do the same thing here?
With modern rules of discovery, it is not any more of a burden on the plaintiff, as in this case where Price Waterhouse turned over everything that had gone into this decision, and the district court acknowledged that, where unconscious attitudes are involved, that Price Waterhouse has any better knowledge that there's discrimination infecting, subconscious discrimination infecting their process than the plaintiff.
Isn't this a case where the employer knows best what went into it? And why shouldn't the employer bear the burden here of showing the real cause?
Because the employer does not necessarily know any better. They have turned over all of the information that went into it, and it is respondent's expert who established the causation and that there was discrimination here within the process.
In the questioning and the answers, I think I understand the question. I'd like to recast it. It's the employer who says, we have a very valid reason for not making the plaintiff in this case a partner. And the valid reason is, and then you would fill in the blanks. Why shouldn't the employer, therefore, have the burden of proof of establishing why it is consistent with what it is that you represent that the employer should have anyway, and that is the ability to make the calls as to who should be a partner and who shouldn't. That's a management decision. Certainly the employee can only assert why he or she believes, based upon whatever evidence that they can produce, did not receive it. Why shouldn't the employer, therefore, have the burden?
We would point to the statutory language and the decisions of this court, which have said that the employee bears the ultimate burden of proving intentional discrimination.
Which statute and which decision are you referring to? Are you referring to Burbine or what?
Since Teamsters, this court, and Burdine recognized this as well, this court has held that the plaintiff bears that ultimate burden. And the statutory language in the liability and remedial section speaks to but-for causation, saying that the employee has to show that they were adversely affected because of an impermissible bias, i.e. their sex or their race.
Well, in Franks and in Teamsters, I think we held that once the plaintiff class has shown that the defendant has engaged in discrimination against the class, then the burden as to causation for any particular employment decision shifts to the employer. Isn't that right?
Teamsters, I believe, is a disparate impact case, and in Franks, there was a class action involved.
We have transportation management and Mount Healthy too.
Those are not Title VII cases. Transportation, Mount Healthy was a First Amendment equal protection.
The principle is very similar to the equal protection cases
But
in the case like Mount Healthy.
In Mount Healthy, there are significant constitutional rights at hand, that is First Amendment and equal protection rights. Title VII recognizes competing
It's a
interests.
little like a tort case under tort law, where there are two possible causes and the actor knows best and the burden can shift.
But in a tort case, negligence has already been established. In a Title VII case, there is not causation shown until but-for causation is shown, and that is the ultimate inquiry. So tort cases are distinguishable in that regard. In conclusion, we would ask that this court reverse the decision of the Court of Appeals, and if it should find the preponderance of the evidence is the appropriate standard, remand for a hearing on that standard.
Thank you, Ms. Winterburn. Ms. Fenston?
If it please the court, I will be arguing 2 points.